Good morning, dear friends. A hearty good morning from the web desk of Bhattacharyas and Associates. This is Bodhan Bhattacharya, the managing partner, greeting you. After a long time, especially the pujas and the festivities, we have met, and it's well met. Today's topic will be the maxim, king can do no wrong. Now, this is one maxim which has raised many eyebrows, which has given birth to many controversies. And this is one maxim which is perhaps quoted copiously even in the literatures, various literatures. Now, the doctrine of king can do no wrong, I have faced quite a few times this question that whether this is still a doctrine which can be used in the modern perspective. Can it be? Then there are questions like, was it only applicable in the yesteryears, especially where there lived the kings and queens, especially in the Western world, or is it still applicable in India? So these are the questions that today I tend to search for the answers. First and foremost, let us come down to the boiling point that when the maxim originated, let us kindly have a look at the time and the period when this maxim had originated. This maxim had its roots in the ancient laws of Western systems. England, we have France, we have these European countries championing these doctrines. Why so? This is because the theory of king being a part of divinity, king being a divine ruler, was propounded perhaps in the English ecosystem of legality, and the suit was followed by the French. So if we today look at the English system prevalent at that point of time, the church used to endorse a king, and the king was held to be the God incarnation, like he is the God in flesh and blood. So the king was the direct descendant of God. Whatever he does, that's the law of land. Nobody else can, find fault with the king's judgment. Whatever he does, that's the law. So that's how the doctrine of king can do no wrong originated. There is a saying, not very factually supported saying, but nonetheless a saying, a proverb. Sometimes this is also taken as a legal fable, that a king in England, once upon a time, he took to his council of advisors and he asked them, or rather he ordered them to search out and fish out for a law so that he can marry his own sister. Whether there is any precedence of that or there is any law supporting his action, he wanted that. And that king gave his council of ministers and advisors a finite time, that within such time you kindly look it upon, otherwise joy will be the consequence. After the deadline was over, he called upon these advisors and asked, what have you unearthed? All of them nodded their heads and said, no, we haven't been able to find any such dictum of law in your favor. So he ordered his executioners to get all those cabinet of advisors executed. Now the eldest advisor, he comes forward and says, no, we haven't found any laws, right? But we have found something which can be passed as a law. And what is that? This is then they say that in the wisdom of the council, today we deliver a decree that a king can do no wrong. So whatever the king does is the legislation, is the statute, is the law itself, and nobody can challenge it. So that was the genesis of the doctrine of king can do no wrong. Now, after the advent of the ages, with the advent of ages, with the actual emancipation of humankind, with actual, when the people became more liberated, this maxim thereafter started coming with different layers. There were three layers which could be observed. Firstly, as I had said, that the king was above law and he couldn't be implicated in any of the proceedings. Thereafter came the king who did not function by all by himself, so he had his own minister in charge, and therefore the minister in charge used to countersign the decree of a king, and whatever was done pursuant to that decree, the minister in charge became responsible. That is also not very acceptable. Third one was this, that if the king passes an order and an official, he carries out that order. While carrying out that order, he commits certain mistakes, then the official is found answerable. That's the third part or the third layer. Although all these three layers, I do not think that has much application in the Indian systems of law. Now, coming to the Indian system and avoiding the historical perspective any further, if we come down straight away to the Indian system and the prevalent Indian system, I should say, then also, in my humble opinion, king can do no wrong, this maxim has a very particular, it has an implication. It has such an implication which cannot be overruled at this point of time. Even we have certain provisions like Article 361 in the Constitution, where it says the president and the governors, they are above, they have the sovereign immunity. They have the sovereign immunity, nobody can sue them. Then you have provisions under the Indian Penal Code. Whenever a public servant acts on good faith while discharging his duty, even if he acts mistakenly, he will be immune to that extent. Now, kindly note, I am not talking about sovereign immunity right now, because sovereign immunity is a bigger concept, and I do not think just a sermon over the YouTube can explain the doctrine. Sovereign immunity, I will come up once again with certain slides and shows, then that will be clearer. But I'm just I'm just scratching the surface of sovereign immunity here. Sovereign immunity we all have. I mean, we in the sense, sovereign immunity we have for the states, not the head of states, because say India or Bharata is a concept. India has a sovereign immunity. The crown, the legislatures, they have sovereign immunity. Now, what is this sovereign immunity? Today, the actual ramification of the doctrine will be, if I say king can do no wrong, kindly mark my words very carefully. King can do no wrong means, being the king or being the head of the state, you cannot do any wrong. Now, this word cannot symbolizes you do not have the authority to do any wrong. It is not that whatever you do is law, or whatever you do that is legal. It means that you have no authority to do excepting whatever is legal. Meaning, when you do something illegal, then you do not remain the king. The sovereign does not remain a sovereign. When it flouts the law, it becomes triable, just like an ordinary citizen, just like an ordinary person in the eyes of law. That is the question of equality. That is the tenet of equality that our constitution imbibes. Article 14, 19, Article 21, Article 16, so on and so forth. So this is very essential, and it is ought to be, it's ought to be regarded with such a sanctity, that in our universe, the Indian universe, if I say, then a sovereign gets the sovereign immunity from his subjects. I'm not talking about a dispute between two sovereigns. I'm talking about a dispute between the sovereign and his subjects. The moment the sovereign acts illegally, then he does not remain a sovereign in the eyes of law. In the sense, he does not enjoy the immunities that the sovereign has in the eyes of law. He becomes completely triable before the courts of law. So that is how the doctrine king can do no wrong still holds valid in the Indian context. So that was a small tidbit of an information from the web desk of Bhattacharya and Associates. Many of you had put this question through many of the platforms. Just to clear out the air on the subject of king can do no wrong, I have not gone into much depth, much greater details, but just gave you the basics of the ideas of what is all about the doctrine of king can do no wrong, how it came, and how it remains today. Very consciously, I have not pondered over the intermediary phase, like how it came, I mean, how it was originated, and how it developed to this state. But I have just confined myself to how it originated and how is it today in India. And that will be all for today's small snippet video from the web desk of the Bhattacharyas and Associates. Vande Mataram.